Well, good morning, ladies and gentlemen, and welcome to the University of Birmingham and Birmingham Law School. I'm Joanna Gray, I'm Director of Research, and here on behalf of the Head of School to welcome you all today, and most of all to thank all our panellists and speakers today, and Luca Rubini and Rilke Greco-Vallis and Aiju Chen for having the bright idea to get this together a few months ago now, and they've worked very hard. And what's particularly pleasing to us is that this is a joint venture between our rather wonderful postgraduate research student community. The impetus has very much come from them, so pay particular tribute to Aiju Chen and her colleagues. And we've got, like all law schools these days, we have a mission. And we like to think of ourselves as having three defining characteristics at Birmingham Law School. And those are that we're global in outlook and we're diverse in outlook, but we're also civically rooted, mindful of our history and tradition, right at the centre of this city of 1,000 trades and formerly known as the workshop of the world. So I can think of no more apposite topic for a post-Brexit Britain and Birmingham's and the Black Country's place in particular in reclaiming that title. This is we're addressing the very practical issues of the world beyond Brexit and what the new relationship between the UK, the EU and the wider world will be in terms of trade. So I will hand over to Luca now and look forward to today's discussions. Thank you.
Now we move to Lauren.
Yeah, well, I just want to begin by saying that being a trade lawyer is a bit of a difficult thing to do because unlike most areas of social life, the lawyers haven't quite monopolized the field and converted it into our own language. So when I started this, I thought I'd try and find out what these agreements were all about, and that meant I had to read some economics, and then I looked at the agreements and I realized that isn't actually what was in the agreements, and then I discovered one needs negotiators and people with practical experience and political scientists to explain why the agreements actually fail, usually, to meet the high standards of economists. So a lawyer comes very much at the end of all of this. So what I want to do today is start off with my views and the opinions, essentially, because this is very speculative and people have different views on what's likely to happen now. And then sort of launch into an explanation of what I think will become important in the medium term, which is the UK's position in the WTO. So the first thing is, I think, when Article 50 is triggered, which is, I think, on current predictions, either the 15th of March or by the 31st of March anyway. My view is that sets into train a 2-year time period, a bit like with the train timetables in the First World War, and I don't think that this period can be suspended or stopped or reversed. I think arguments such as the Parliament seems to be assuming at the moment that a notice under Article 50 is revocable, I think those arguments have no basis. It doesn't say anything about revocability in Article 50, and one can talk about what customary international law says on the point. In fact, most people misunderstand this. They refer to, for instance, Article 68 of the Vienna Convention on the Law of Treaties, which talks about revocability, but revocability in very particular circumstances, which is when something has actually gone wrong with the treaty. Nothing has gone wrong with the EU, well, some people might say it has, but nothing of that sort has gone wrong with the EU treaty, so we're not talking about remedial revocability. And I think what's more important is that Humphrey Waldock, in the drafting of the ILC articles that led to the Vienna Convention on the Law of Treaties, failed to introduce or to have accepted a provision which would have said all notices to terminate a treaty are revocable. And why? Because you play games that way. The United States did this quite famously with the Montreal Convention. It was the Warsaw Convention on aircraft liability. Threatened to withdraw, got what it wanted and then didn't withdraw. Everybody knows this, and I think Article 50 has to be read in that light. So the Parliament is wasting its time, essentially. What does that mean? Well, that means that the UK's relations with the EU and with other countries and via the WTO are going to be, I think, as soon as the notice is given, up for grabs. And what will that look like? Well, first of all, I think there will be no trade agreement with the EU before the end of the 2-year period. I just can't see this happening. And that's not for legal reasons. I think legally it could be agreed. Even Barnier seems to be, the negotiator on the other side, seems to be of that view now. But I think it's for political reasons, and it all comes down to free movement in the end. After all, the important thing about the Swiss example is that they have free movement forced on them. And that's only with a goods agreement. Right? There's no services in the Swiss bilaterals, except for something minor on non-life insurance, which I think doesn't really happen anyway. So if a rich country has to put up with free movement just to get a goods agreement, talking, for instance, about the Turkey precedent, which has goods but no free movement, is completely irrelevant. And that's because the EU knows full well that moving people around is a cost to the country where they are going, because, after all, who likes that much immigration? You can dress this up with economic arguments, but it's all nonsense. So this is a price that the UK would have to pay. I think this isn't going to happen in the next 2 years. There's also, of course, another aspect, which is also in terms of how long it would take to agree agreements. Well, this is a divorce, not a marriage. And that means that, on the one hand, undoing things can be a little bit easier because you're just deleting free trade, but it also means that the climate for negotiations is significantly different. And that's another reason, I think, why we won't see anything happening. So what does that mean will happen? Well, first of all, I think that there will be trade barriers of a most favoured nation type between the UK and the EU. Secondly, I wanted to say something about the free trade agreements, which are currently EU member state on the one hand, mixed agreements, and then third countries on the other. And there are a number of these agreements which cover about 50 countries or so. My view on what's going to happen there is that the UK remains a party to these agreements, formally speaking, because, after all, it is a state that concluded these agreements. It ratified these agreements and it's bound by these agreements, so unless it validly terminates these agreements, they are binding on the UK. But I also think that doesn't amount to terribly much, because if you look at the agreements, the rights and obligations in the agreements are all described as being for the EU and its member states. And in that respect, I think once the UK stops being a member state, it stops getting anything under the agreement or owing anything under the agreement. In other words, I think the UK is a party to an agreement which is no more than a blank piece of paper. Interestingly, if you include the termination clause as one of those provisions that can only be exercised by an EU member state, that means that this will go on forever, because there's no other basis for terminating these agreements. I think there is an argument for saying that some clauses like that can actually still be invoked by the UK acting in its own name. But this all needs to be worked out. The short conclusion to come from that is that the UK is going to need to renegotiate market access that it loses as a result of those agreements, in effect, dropping out for it. And then we come to the WTO, which is the backdrop to all of this. And here, I don't like to assume that people know too much about this, but essentially the WTO has two types of rules. One is generic, don't discriminate, or do a risk assessment if you want quarantine measures or something like that, and that applies to all WTO members. But then you also have what are called schedules of concessions and commitments, and these are promises that are made by each WTO member not to impose more than a certain trade restriction in goods and services, and all the others then ideally agree with this. And that becomes a legal treaty obligation. But the important point is that each WTO member has individual promises which have been agreed by the others, and this is all done by negotiation. And it's those promises that I want to talk about, because, as Lilia said, there's no suggestion anywhere, it's never been made by anyone serious, not even journalists, I think, that the UK is not a WTO member and will not continue to be a WTO member. The question is, what does that mean for its obligations? And I think it also has not been said that the UK will lose any of the first category of obligations, which includes dispute settlement, by the way, and procedural obligations. So the argument about the UK's maybe somewhat fragile position in the WTO is all to do with the second category of commitments, let's call them, or concessions, which are these promises which either have or have not been made by the UK. Now, the sceptical argument is that the UK doesn't have any obligations like this. Now, people who adopt that argument don't usually follow through, which is the follow-through is, well, good for the UK then. No? I mean, if it doesn't have the obligations, it doesn't have the obligations. That's fantastic. And they assume that there's actually another proper obligation to have these schedules of commitments and concessions. And it's true that there is in the GATT, but there isn't anywhere in the GATT for goods. It's just not there. So that's one difficulty with that argument. But I think the real problem with the argument that the UK doesn't have these sorts of concessions and commitments is I think it's just a misunderstanding of the law. So that's what I wanted to illustrate a little bit. But this assumption that the UK is somehow in a difficult situation in the WTO is often trotted out, not so much anymore by the Director General of the WTO, who's now more silent on this point. But you do read about it a lot. It does still seem to be the conventional wisdom, and every now and again you'll read something like, oh my God, the UK and the WTO now is going to have to give the Falklands back to Argentina because Argentina's agreement is net. It's all complete nonsense. So I want to explain why it's nonsense, which is, I think, of some legal interest aside from this, from an international law point of view. So essentially the argument that I want to make is that well, first let me explain how these schedules look and why there is even a question. So as I assume everybody knows, the EU has an exclusive competence in the area of goods and always did. And in the area of services, back in 1995, it wasn't all that clear. And then the European Court of Justice actually said, no, the EU doesn't have an exclusive competence in services, even though now, with very minor exceptions, it does. But what this all meant was that in 1995, it was known that at least in the area of goods and to some extent in services, the UK was constitutionally unable to make any promises, which is, or indeed conclude any of the WTO agreements over which it didn't have any competence. And this was seen to be a little bit of a problem, and I think nobody really knew what to do about it. So the legal solution to this was pretty much a terrible mess, I think. And this is the way I think it panned out. So what the EU did is it came up with a schedule, two, one for goods and one for services, and the good one just says European Union because that was an undoubted exclusive competence. And the services one says, European Community and its member states. That was what happened in 1995. I just want to take the goods one because that's the harder case. The question is, how can the UK have any obligations under a schedule which has European Union attached to it? Surely it has to be the case that when the UK drops out of the EU, it also drops out of those commitments in the same way that I said it drops out of obligations and rights as well under free trade agreements. Well, I think that's not the way it works, and I need to run you through a little bit of detail to explain this. So the first thing to explain is how these schedules become commitments in WTO law. Originally, what happened was there was an obscure instrument. Usually when I teach, I never refer to this really, but I've become more familiar with it, known as the Marrakesh Protocol. And the reason is its job is done. It doesn't. It's just sort of historical. But the Marrakesh Protocol, not to be confused with the Marrakesh Agreements, the Marrakesh Protocol was all about annexing schedules of new WTO members to the GATT. In fact, it deemed them to be annexed to the GATT. And what it said in paragraph 1 is that the schedule annexed to this protocol relating to a member shall become a schedule to GATT 1994 relating to that member. Now, the phrase schedule relating to that member is important because it links directly to obligations in the GATT. Most importantly, Article 2, Paragraph 1b of the GATT, which, I'll read it out to you. The products described in the schedule, relevantly, relating to any contracting party, now member, shall, on their importation into the territory to which the schedule relates, so you can see all this relating to member business, be exempt from ordinary customs duties, etc., in excess of what was promised. So you've got reference there to schedule relating to a member, schedule relating to territory of a member. And of course, the first question will be, well, surely that's the EU in the context of goods, because it's the EU that annexed this schedule to the GATT. Why are we even talking about the member states? And the problem with that argument is that it ignores a very important provision, which is Article 11.1 of the WTO agreement, which says that every original WTO member must have a schedule annexed for it. Now that's very peculiar language, having a schedule annexed for it. Usually it would say it must annex a schedule. And in fact, it says that in the GATT. Every WTO member must annex a schedule. So what does it mean to say that you can have a schedule annexed for you? Well, clearly, given that the EU member states and the EU were all original WTO members under this provision, this had to mean that, and this is where this was a complete disaster from a constitutional point of view, I think, but at international law we don't care so much about that, had to mean that the UK would have a schedule annexed for it by whatever organ in this complicated EU world was competent to do that. And in services, correspondingly, to the extent that the EU didn't have exclusive competence in services or any competence in services, if this were necessary, because no one knew at this point what the court was going to say, that that aspect that might still be within reserved member state competence would be annexed to the GATT. This is the way I see it. Now, another important aspect of this is what Article 2 and the GATT that's through GATT as well says about territory. So if you accept that the member states, and I'll just say the UK for short, that the UK has a scheduled obligation of its own because there's a schedule annexed for it to the GATT, then one has to identify what this might mean for the UK, and here the important point is territory. International law is effectively based on territory, with certain exceptions, but this has got to be the starting point. Article 29 of the Vienna Convention on Law and Treaties says this expressly. A treaty applies to the territory of a state unless there is a reason to believe otherwise, as implied from the treaty or said or whatever. And in this particular case, I don't see any implication that there is anything to contradict the standard rule, which is that when the UK, for instance, ratified and accepted the WTO agreements, it did this in respect of its territory. Now, what does that mean? It means that the scheduled commitments for the UK were promises by the UK not to impose more than, say, 10% duty on cars coming into the UK. What it cannot have been is a promise by the UK to not impose a customs duty of more than 10% on cars coming into Germany. That's not the sort of thing that you can do under Article 29 of the Vienna Convention. And correspondingly, all the other member states have territorially limited schedules of concessions. Now, why does nobody see this? Because it's unnecessary to see, because what I would propose is that these schedule obligations exist at two levels. There is the level that I've just described, which is the member state level. And then there's another level, which is the EU level. The EU is a member in its own right, and the EU also has obligations. So what I would say is that the way to look at this is you've got the EU level of scheduled obligations there. You've got the member states, which is an aggregation of, at the moment, 28 territorially limited schedules of concessions. There's another reason we don't think about that level, which is between these member states there are no duties imposed, but that's only because of Article 24, which permits free trade agreements and so on. And also there's a customs wall outside, which happens to match perfectly with the European Union, because that's how it happens. That's why we don't see this. But just because it's invisible doesn't mean it's not there. More complicated is that what I've been talking about so far mainly is obligations, right? Scheduled commitments are obligations. What do we make of the fact that the EU speaks in the WTO? The EU turns up in court when required. Well, my view on that is that that has nothing much to do with obligations, not in the first instance, but that is to do with attribution. And this is, I think, the interesting aspect from the international law point of view. Obligations are one thing, that's about the law. Attribution is another thing, that's about facts. Basically about facts. It's about what states have done and who is going to be responsible for what states have done. Well, here the two levels come in. So I would say that when the EU stands up in court, what it's actually doing is accepting responsibility for the acts of a member state when it is the act of a member state, but you need to tie that to an obligation. And that essentially means that the EU is defending its own obligation, but taking responsibility, which you can do under Article 11 of the Articles, you would adopt responsibility. There are other ways of justifying this. You could say that the member states are organs of the EU. Commission lawyers have a range of ways of explaining why the acts of member states are attributable to the EU. It doesn't really matter. The point is that the EU says those were our acts. Those were our acts, and if there was a violation of our obligation, well, that's fine. We will handle that. It's all ours. And yet again, you can see how the member state level disappears. Now, I should say at this point, there is a complication, which I haven't read anything on, which is that the schedule at the moment actually has just been updated in December of last year. It covers 25 EU member states. It's the same with services, actually. I'm talking about the goods one, which leaves 3 alone. That's Romania, Bulgaria, and Croatia. Interestingly, the EU has withdrawn their scheduled commitments, which might lead you to ask, what the hell is going on there? If you wanted to, if the Croatians started to impose 20% on cars, what would actually happen there? Well, I think that the way I would analyse that is to say that the withdrawal is ineffective, that Croatia is, to use that example, has to be still bound by its commitment, and if the EU steps up in court to defend, as it would inevitably do, the proper way to look at that would be something different, which would be the EU putting its organs at the disposal of Croatia in order to help Croatia meet its own obligations. Until the schedule is parallel, I think this has to be the only way to look at it. Otherwise, the EU certainly hasn't got any obligations with respect to Croatian territory. It just doesn't. And if you didn't look at it this way, then Croatia wouldn't either, and that can't be right. So this is the way I think it works. So you've got to have this double level, and then within each level, you need to divide it up according to obligations and according to attribution. And if you mix and match all of that in this shell game that I've given you, it all works out perfectly, I promise you. Now, to go back to the UK, you're with me on the idea that the UK has current obligations. And I should say this is the government's position as well. On the 5th of December, the Secretary of State for Trade, Liam Fox, announced to Parliament that the UK would now try to replicate as far as possible in the WTO its current obligations, which makes the important point. These are current obligations. And how would it do this? It would do this by submitting new schedules with the words United Kingdom at the top instead of European Union. And I should just say that doing that is not unique. It's not the first time. In fact, the majority, well, maybe not majority now, but the majority of WTO members at the time the WTO was formed, which is to say, I think it was 60-something WTO members, began their life as GATT contracting parties by doing exactly the same thing when they became independent, when they became ex-colonies and newly independent countries. That's exactly what happened. There would be a metropolitan schedule that applied to those territories, and then when they became independent, You just take out the bit that applies to that territory and you write your name at the top. This is standard practice, was standard practice until 1995. So doing that I don't think is particularly novel if one wants to go down that route, I think. But if we have a UK schedule, let's say, a proposed schedule, which is what the government's going to do, it's going to come up with what it thinks its share of the EU commitments are that are applicable to UK territory. Are there any difficulties with this? Well, I've got a couple of points to make on this. So the first is it would seem to be fairly straightforward to say that if there is a generic duty rate that applies to products from all countries, of, let's say, the famous 10% on cars, then it shouldn't make any difference if the UK is now promising a duty of 10% on cars coming into UK territory, and then there's still the 10% duty on cars going into the rest of the EU 27, and it shouldn't make a great deal of difference. And I think that sounds simple, but there is a complication, and then there's an answer to the complication. And the complication is not to do with final products, where that's basically the end of the story, right? There's a little shifting supply lines, there's some difficulty maybe that one could envisage, but that's essentially the end of the story. But where this is a really big problem is when you're talking about exports into the UK, and it's the same the other way, but I'll use the UK as an example, of component products and component services. Because if you are Korea and you export car parts to the UK, or you are Nissan and you export car parts to Sunderland to be turned into a UK car, because the car then has UK nationality, and that car can't anymore go to the rest of the EU 27 because of the 10% customs duty hit, so that market has dried up, so there's no more UK cars. There's also no market for car components that come from Japan or Korea. And so they will say, well, hang on a sec, we've just lost, de facto, we've lost market access for our car parts because nobody's buying them anymore because your factories have just shut down. Why is that a problem? They say it's a problem because when we negotiated with you via the European Commission and so on, but when we negotiated with you, we expected that we would have this market, and if we, that is the only reason why we allowed you to flog all your widgets and gadgets to us. And if we are no longer able to sell car parts to you, and it's the same with services, any inputs, then the reciprocal balance that we negotiated has become unbalanced, and that makes us very unhappy. And that sounds like a plausible complaint to make, and it's certainly a plausible economic problem that I think is almost certainly going to hit third countries, any third country that exports components of goods or services to the UK. But that doesn't mean that it's a sound legal claim. And that's because this is not protected by WTO law. This is just bad luck. What WTO law protects is negotiated access to a market. When you get there, it's non-discriminatory. In this particular case, what's happened is that the market has dried up. And that is just bad luck. Reasons for markets drying up don't matter. And there's a case on this point, which is the one of the many bananas cases. This one's the Article 22.6 arbitration, where the United States was annoyed because banana plantations in Ecuador that it owned, from which it was exporting to the EU, those bananas were being discriminated against. Problem was that owning those bananas doesn't make them US bananas. They were still Ecuadorian bananas, but the US wanted to get some damages out of this. So it made this claim in these arbitral proceedings. It's lost market access for fertilizer that it exports from the US to dump on the Ecuadorian bananas, because there aren't as many Ecuadorian bananas as there should be, because the EU isn't buying them as it should be. So it's exactly the same for car parts, fertilizer, car parts, and the arbitrator said, no, forget it. That's not protected. So, valid economic gripe, invalid legal argument. It's just bad luck. Everyone suffers together. Now, the other problem, which Lily just mentioned, and I'm not going to go on about it at too much length because it is a bit technical, is to do with commitments that are in a quantified form. you don't have this problem with a 10% customs duty, right? 10% here, 10% there, it's unquantified. But you have two types of commitments which are in quantified form on an EU-wide basis. And one of these is what are called tariff rate quotas, which are basically quotas the EU promises to let in 100,000 tonnes of beef a year. It doesn't specify where this goes once it gets to the EU. At duty-free rates or low duty rates, as opposed to the normal duty rate, which is higher. Now, the problem is, what do you do about this 100,000 tonnes of beef? I mean, what share of that is the UK's share, and what share of that is for the rest? I mean, it's essentially like, who gets the house in a divorce? How are you going to figure this out? Now, there are some people who say, oh, well, there are no rules on this, and therefore the entire theory has to go out the window, right? Because if you don't have rules, that means we must go back to square one and say that the UK doesn't have scheduled commitments or something. People say things like that. I think it's absolute nonsense, needless to say. As lawyers, what you do in a situation like that is you just make it up. And there are ways that you can make it up. And the standard WTO way of making up something like that is you look at the last 3 years of trade. In this case, you're looking at trade into UK territory. And I know that there are people in DEFRA in the basement, it's an unlovely job, doing this right now. Trying to figure out how much lamb, beef, whatnot has been coming into the country. Horrible job. It's got to be done. That's just the way life is. And they do that for 3 years and talk to the other countries, and I think that's how that will be sorted out. Now, what if the other countries, and this I'll finish on, what if the other countries don't like this? There's the second quantified element is to do with subsidies, but it's a non-issue for other reasons, because basically those subsidies don't happen anymore. What if the other countries don't like this? Does Britain have to give back the Falklands? Well, no, because on this theory, the UK has obligations anyway. So the new schedule of concessions is a draft, it's a proposal, it tidies things up. But if the other countries don't like it, then you can argue about how much of a quota the UK should be offering in dispute settlement. That's essentially your route. Or you can commence a process of negotiations, which if that fails, allows the other country to retaliate. And if the UK disagrees with that, you're back in dispute settlement. So one way or another, someone is going to have to figure this out. And it's either someone in the basement in DEFRA, someone in the basement in Wellington, or someone in the WTO building. A panelist, probably helped by a whole lot of interns and so on. Someone is going to have to figure this out. The important point is it's got to be done on legal principles, which may have to be invented, but I think that they can be invented. I don't think it's that difficult. The retaliation, I should say, if it comes to that, is limited to trade damage. So you need to figure out if the UK's got it wrong. If it's got it wrong, not at all, well, then there's nothing to complain about. If it's got it wrong a little bit, you retaliate a little bit. But at no point, I'm sure everyone here will be glad to hear, do the Falklands go to Argentina? Okay, very quick point on state succession. What does one do with the government procurement agreement? And I want to mention this because I think it has implications for all of the other EU agreements. And so I think it's just an idea that's worth putting out there. The government procurement agreement is a special agreement in the WTO world because it's so-called plurilateral, and that means you need to sign up to it specially. And the EU signed up to it, but the member states, not all of them anyway, and I think none to the more recent version, have signed up to that. So the UK is not a signatory to the government procurement agreement. And yet, if you look at the government procurement agreement, it also has schedules of commitments which say things very specifically like the UK will make sure that the trade ministry doesn't discriminate when it buys staplers, when the value of the staplers is over a certain level, stuff like that. So it's very specific and mentions the UK and so on. Can all of that simply fall away? And does the UK correspondingly lose all its rights in respect of government procurement by other parties to the government procurement agreement? Well, I think not, and also I'm pleased to see the government seems to be adopting this view as well. Why? On the view that the UK leaving the EU is like Scotland leaving the UK, and rules on state succession apply. Now, those again are all based on territory. Now, I need to defeat a couple of arguments against this, I don't think with much difficulty. The first is to say that it can't be the case because the EU is an international organisation and the UK is a state, and therefore there is a treaty on this from 1978. Therefore, the treaty doesn't apply. I'm not talking about the treaty, I'm talking about customary international law about precisely this situation, which has happened a number of times, not very often, mainly in the 19th century. Union of Colombia, Union of Norway and Sweden, because you're part of the world, Mali, Senegal, there were lots of these unions, even the Federation of Nyasaland and Rhodesia in Africa. And each time, with one exception, the idea has been continuity, just like in state succession, that the units that leave inherit the obligations as they apply to their territories. The other objection is to say, if you look at what happened in the United Nations from 1989 onwards, dissolution of the Soviet Union and of Yugoslavia, all those countries had to reapply for membership, but that's a totally different situation. The rule on membership of organisations is different. You do have to reapply, but we're not talking about membership, to get back to the very first point. The UK is a member. It's just a question of what multilateral rights and obligations does it inherit. So I think state succession is a genuine possibility. The way I would look at it is like this. Should it be possible for a state to join an international organisation, give it exclusive competence, and this I think is a critical point, which makes this unique pretty much, because organisations don't usually have exclusive competences. Give it exclusive competence to do X for, 40 years, then leave the organisation and say, well, that wasn't us. That was them. Seems to me that this doesn't match the principle of continuity that rules on state succession are essentially based on. But beyond the government procurement agreement, this, if this is right, applies to any area in which there is an EU agreement and an exclusive competence. And there's a hell of a lot of that out there. And in fact, that might even be an alternative theory for understanding the position of the UK in the EU FTAs, although I doubt anybody would be game to make it. But I'll just throw that out there. I think state succession is a live idea. All right, that's it. Thank you.
Thank you, Lauren. Thank you very much. A very rich and clear presentation. It's good to hear that everything has been sorted out or can be sorted out quite easily with respect to the UK position in WTO. So now we move to Rob for a few comments.
I'm going to start by venturing a little outside what, with all due humility, I would describe as my area of expertise or specialization, which is WTO and international economic law more generally, and start by challenging Laurent on the issue of reversibility under Article 50. So Laurent says that there's nothing in the text of Article 50 that suggests the possibility of revocation or reversal, but there's also nothing in it that would make it impossible to do it either. So I think we would have to distinguish several different situations. One would be a situation where there's a change in the political decision in the UK, and it results in Parliament deciding to revoke the authorization of the government to move forward with the Article 50 procedure, and on the constitutional principles that were elaborated by the Supreme Court of the UK in its recent decision. I think it's very clear that what Parliament can authorize, Parliament can revoke. That's clearly part of the constitutional framework in this country, as I understand it. And indeed, it's a principle of parliamentary democracy generally, subject only to specific constitutional restraints. So on the domestic constitutional plane, I don't think there's any problem with reversibility or revocation. And so let's say that Parliament decides to do that it's dissatisfied that the public seems to be increasingly negative on Brexit, and the Parliament is dissatisfied with the way that it's being negotiated by the government, and decides to to essentially reverse the process, to tell the government stop. I don't think there's any legal obstacle to that under UK law. And then the question is, what about Article 50 itself? And so there could be several different scenarios. I mean, one scenario is that, and we're going through multiple elections in Europe that will determine in some important way the orientation of European politics, including concerning integration over the next few years, and one can't make any hard and fast assumptions. So one scenario is that there's a decision of the UK Parliament to halt this, but the other EU countries say no, we don't want the process reversed. We've already started to plan the future of the EU without the UK, and we have a reliance interest in it going forward. It seems to me that whatever the ECJ said about the interpretation of Article 50, it would be, as a political matter, extremely difficult for the UK to, as it were, force its way back in. But I think since it's more a matter of politics than strict law, that it really depends upon the point in the process and the political environment in the rest of Europe. So we could take the alternative scenario that the leaders of the major remaining members of the EU actually would be happy to have the process reversed and have the UK stay, perhaps under somewhat different terms or somewhat different arrangement. And we know also already that we have a variable geometry or multiple speeds. There are some countries in the Eurozone or not. There are some in Schengen and not in Schengen. So it's not inconceivable in any way that and already in some sense the UK is out of some of these arrangements as it currently stands. So there could be further asymmetry, but it would all depend, I think, on the will to want on the part of the European partners to want the process to stop and to perhaps reintegrate the UK on somewhat different terms that have greater domestic legitimacy. In that scenario, I don't see any interpretation of Article 50 as stopping reversibility. If the main European partners want the UK to stay in or to be reintegrated on somewhat different terms, I think it would be, from all I know about the ECJ and the text of Article 50, I think it would be essentially inconceivable that the ECJ, based upon an ambiguous legal provision that's never ever before been tested or interpreted, would decide to fracture the European Union where there's the political will to keep it together with the UK inside. So it seems to me that reversibility really doesn't depend so much on interpreting the absence of either an endorsement of it or a rejection of it in Article 50, but on the evolving political climate in Europe. But what's clear, and where I think those who've said this in the House of Lords are absolutely correct, on the constitutional plane in the UK, there's absolutely no problem with Parliament saying to the government, stop, or hold off, and we don't want this for now to go forward. And how that's treated by the European partners, as I say, will be very much dependent upon the evolving political dynamics in countries like France, Germany, Italy. Now, just to move on to the WTO issues. Here, I really agree with Laurent, and when people ask me about this set of issues, I usually recommend Laurent as the first point of reference. It's certainly the case that the UK was a founding member and is a full member of the WTO. On the issue of attribution, my analysis comes to the same result as Laurent's, though I'm less sure that I get to it by that route, and that may be due to a technical consideration, which is that I believe that the established rules of attribution in customary international law are based upon conceptions of state responsibility, not the international responsibility of international organizations. There is a draft there are draft ILC articles about the responsibility of international organizations and the responsibility of individual states within the framework of international organizations, but they're controversial. Many international lawyers don't think they're very good, and they raise a lot of difficulties which relate to the existing state of the law of international organizations. So I think that using attribution to solve the issue is messier than perhaps Laurent is letting on. But what seems to me to solve the issue or the puzzle at the WTO level is that there's an acceptance by the WTO membership of the character of the EU as a customs union. That's a fundamental premise of, in fact, being able to operate the GATT Article 24 MFN exception. So accepting, that the EU as a customs union is a basic legal premise of its ability to operate within the WTO legal universe. And what follows from that premise, one of the conclusions that follows is that there's an understanding that the EU will have international responsibility within the WTO legal framework for the acts and omissions of its members that constitute breaches of the primary obligations in the WTO treaties, and therefore correspondingly that the appropriate respondent in cases that raise issues of actions of member states that may breach the primary obligations is the EU itself, the authorized agent of the customs union. So I come to the same conclusion, I think, though through a rather different chain of reasoning. Now, I want to just raise one final point, because I'm not sure here I've even fully understood Laurent, and that's not out of any lack of clarity on his part, but just, I think, due to the complexity, some would say mind-numbing complexity of the issue. We would both agree, and Laurent presented the reasons why very nicely, that the existing EU schedule is also a schedule on behalf of the UK, obviously as territorially delimited, as Laurent expressed. And that, therefore, there's a valid schedule that arguably that would govern the relations between the UK and non-EU countries who are WTO members. But because that, as it were, the scheduling of the WTO was premised upon the UK being an EU member and part of the EU customs union, it's obviously a stretch to say that these are also schedules that could govern relations between the UK and other EU members. I just don't see how that would be possible. I don't see the requisite element of state consent, because there was a customs union at the time at which the concessions were negotiated. There couldn't be possible agreement that these concessions would apply between the UK and individual WTO members, other EU members, in the case that the UK would leave the EU. I think that's stretching beyond the limit, the notion of implicit state consent. I just don't believe that there's the requisite consent to be bound in this particular situation, which leaves us, to my mind, with the question of the operation of the MFN provision in the GATT. Is the MFN provision the fallback? So do we say, okay, it's true that the schedules are not binding on the UK and other EU members in relations between them because the schedules were devised on the premise of a customs union, so that they would only apply between EU members and non-EU members. But the MFN provision functions autonomously, so that there's still an obligation of the UK as a WTO member to provide MFN treatment to the other EU countries, at least considered as individual WTO members, which would mean that it still has to give the best treatment it gives under its schedules with non-EU members to other EU members. Again, it's a stretch in a way, because its ultimate result is that the application of concessions that were never consented to as between those particular states' parties. But I nevertheless raise that as a question. The final point, and it seems to me this is a big picture point, and this is why wherever we might have some differences of nuance, or I might have some questions for Laurent on the fine details, this is where I think his overall approach is the correct one. I mean, we've lived through, at least some of us of my age have lived through, the end of communism, the breakup of the former Yugoslavia, the former Soviet Union, and so on. A lot of situations where there were enormously complex transitional challenges, and the need to reestablish, certainty and to protect basic values like the rule of law, open systems of international economic relations, I think often is going to, make, the relevant negotiating partners feel that, they have to get on with the job, even if the technical solutions are novel or imperfect. I mean, take dividing up the debt of the different parts of the former Soviet Union, things like that. Well, there was no formula in international law that could easily apply. You read the relevant experts. There were many different views of how to do that, based on benefit, based on contribution, and so on and so forth. And yet it had to be worked out in order for the former Soviet republics to be able to properly participate in the system of international financial relations. So we can torture ourselves with nightmare scenarios and, display, our capacity as legal technicians by expressing just how complicated all this is in terms of producing a solution that exactly maps onto existing concepts of international law and the existing positive law of all these various instruments and agreements. The solution that comes out will have to be messy and in some ways and may leave further technical puzzles for the future. But there are some overriding objectives, I think, which is preventing, radical uncertainty and, opening up, new and dangerous conflicts in a situation that's in a world that's unstable enough as it is.
Thank you very much, Rob. Great comments. I'm very much conscious of time. We have a little bit more than 10 minutes. So first thing I would like, before opening it up, of course, to everybody for questions, are there any, from the panel, any comments, any rejoinders, quick ones to what the other speakers have said? No?
Maybe just a couple of quick points. On Article 50, it does actually say that the treaty ceased to apply 2 years after the date of the notice of withdrawal. So to get rid of that, you would have to say that somehow, retrospectively, the notice can be withdrawn under Article 50, not just constitutionally. I don't really see that. And in the second scenario that you mentioned, there is actually a way of extending it legally, which is they just sign an agreement that does that. And I think that also supports the non-revocability case, because if Article 50 expressly says you want to extend it, off you go, this is how you do it, unanimity, everybody agrees, then surely the corollary has to be, if you don't have that agreement, bad luck. There's a really interesting point about the commitments intra-EU, and in fact it's even worse in GATT, because the GATT schedule specifically says that it doesn't apply intra-EU. So what do you do about that? I think my answer to that would be to say that what the parties thought at the time, and this doesn't solve the GATT's problem, I don't think they thought anything, actually. Yeah. So I don't know if state consent is going to work. Maybe at best if you had a statement that indicated the contrary. But there's also case law on schedules which says we don't care how you got to this. There's the EU poultry or EC poultry case where Brazil went on about how it only got this quota because of a negotiation, and the appellate body said, well, we don't care, we're not interested in how you got to it. The rules apply anyway. So I think there's a limit to how much one can go back into history. But there is still the problem of the EU schedule. I mean, my view on that is that you deal with this by, again, a territorial principle which comes up in a state succession context, which is you move the frontiers, essentially, and you ignore provisions like that. Because every treaty otherwise would end up dying. You'd have no state succession if you didn't do that. So that's how I would deal with those points.
I just wanted to respond to Laurent. I think that one has to put the 2 years and you're out provision in Article 50 in the context of the whole text of 50. So essentially, there is a process that is outlined in Article 50 for a negotiated agreement, to leave the EU, and the 2 years applies in a situation where the EU members, the partners, have determined that there's been a failure to reach an agreement. So as long as we're on the negotiating track, there's the 2 year cutoff doesn't apply. It does apply if, for any reason, the partners reach the conclusion that a negotiated solution has failed. But what Article 50 doesn't say, quite rightly, is that if you're still negotiating and 2 years has passed since the triggering of of Article 50, then no matter whether you think that a negotiated agreement is still possible but just takes more time, that you just revert to a situation of UK membership being terminated, but without any orderly basis in an agreement. I mean, I think that would be contrary to the purpose of Article 50, which is to ensure, to the extent possible, an orderly transition through negotiated terms of exit to just say if we don't have those in 2 years, that you stop negotiating and there's a termination of the treaty, but without any agreement on the conditions of exit. Now, it's not that we should read out the 2 years. It's a valid provision of the treaty, and it's there for an important purpose, which is to allow for the contingency that that the parties can agree on negotiated terms of exit, and the notion that that should not prevent a state from withdrawing just because the other members can't agree with it on the terms of exit. But my point is that if the negotiating is still going on, there's nothing in Article 50 that says that because 2 years are up, you have to stop talking and the UK's membership is automatically terminated. What Article 50 does say is that if the parties come to the conclusion that negotiations have failed and there's an impasse, then you just go your separate ways without an agreement, after 2 years. So I think there's a lot of flexibility in Article 50, but clearly it becomes much more difficult to reverse or revoke, late in the game. It seems to me that it would have to be at a point at which negotiations are still ongoing, rather than at a point at which they failed, where very plausibly the automaticity of the 2-year termination provision would actually kick in. But as long as the partners are still talking, I don't think the ECJ would want to take the responsibility for triggering a disorderly termination of the UK's membership without some kind of agreed transitional arrangement. Only in the extreme situation where they come to and understand themselves to come to an impasse do I think the court would interpret 50 in that way.
Thank you very much. I would like, of course, to thank the speakers for fantastic presentations, a great discussion, and I hope you will all join me in doing this.